Okay. Good morning, and welcome to the Canmore Local Composite Assessment Review Board hearing. I would like to remind everyone that the ARB hearings are open to the public. Oh, did I not say local? Oh, sorry. Sorry. Local Assessment Review Board hearing. I would like to remind everyone that the ARB hearings are open to the public and that this hearing will be recorded and streamed live. The video recording will be our record of the hearing. Today we are here to review the complaint and subsequent evidence as filed for tax roll number 16683. And the municipal address is 237 Eagle Terrace Road, Canmore, Alberta. I will start the hearing by introducing the panel. will be the presiding officer, and my name is Karen Mara. To my left is Jen Moran. And to my right is Christophe Breyer. And does anyone have any objection to this panel? No?
No objection.
Thank you. I am now going to have the parties introduce themselves, starting with the complainants. Oh, yeah, I will turn it on for you. There you go, sir.
Philip Wilson, 25 plus year resident of Canmore, living at the property in question for over 20 years. We built it.
And you are the owner of the property?
Sorry? I own the property, yes, and have done since I bought the lot when it was new.
Thank you. Now to the respondent.
I'm Deanne Bannerman. I'm with Legacy Municipal Services, and I am the appointed assessor for the town of Canmore.
Thank you. I will now have the complainant present all their evidence first, followed by any questions from the respondent and then the panel. Oh, did I miss something? Oh, yes, I'm sorry. Are there any other preliminary issues, I forgot this for this one, for the panel to address?
I have a question, if that's permitted.
Yep, go ahead.
I'm trying to understand, given the response that I received, are we testing whether the assessor, with the information they potentially had available, made the right decision a year ago, or are we testing whether the property valuation is fair based on the market for actual properties as opposed to whatever algorithm I've not been exposed to that the assessor used? And I think there is a difference based on their response to me between those two questions.
I'm not sure how to respond to that.
Maybe I can help you by explaining why I'm asking the question. They didn't actually respond to my specific evidence. They tried to get a technical dismissal and cited 29 commercial cases for hotels in Edmonton and things as past decisions of boards to get a dismissal, but didn't actually answer my complaint directly. And that's why I'm trying to understand, are we talking about my complaint, in which case I do require an answer to the evidence I submitted? Are we talking about their appeal and their evidence they submitted, which has got nothing to do with the valuation of property and to do with past case history, for want of a better term, on the rules of evidence? That's why I'm asking the question.
Okay, I think we'll wait till...
Well, I can speak to the process of the assessment review board in that the onus is on the owner or the complainant to supply the evidence to prove why the assessment is invalid.
But are you required to tell me why my evidence is incorrect or why you disagree with that? That's the question I'm trying to ask, because you didn't do that.
So I think we can proceed with the hearing and then we can discover that through the process.
Okay.
Yep.
I'm just going to ask the question again, are there any other preliminary issues for the panel to address? And I will ask Ms. Bannerman if she has any.
No preliminary issues. Thank you.
Okay. So we'll go into the hearing and then we can get your question answered.
Yeah, so, I mean, basically this was simple.
Yeah,
sorry.
there's a process, sorry. So, Mr. Wilson.
Yes.
I'm going to describe the process, and then we
Okay.
can go to the process.
Okay.
So there will be evidence presented by the complainant, which is yourself, and then the respondent will have questions, and the board will have questions if there is any. And then the respondent's evidence will give evidence, and the complainant's questions, board questions, if any. Then we'll proceed to the complainant's rebuttal evidence, if any, questions from the respondent, and board questions. And then at the end, we will do an argument summation, a complainant, respondent, and last word by complainant. Thank you for your cooperation and for your presentations. And then we will move into the process. So we will hear evidence from, if anyone needs a break, and if a problem will come up, please let the panel know as soon as possible, and we can address those things as we go. I will also take this time to remind anyone else to please turn off any mobile devices. Okay, so we shall proceed with Mr. Wilson's evidence. No, I'm sorry, I'm missing. Oh, yes, I have it right here. My apologies. So we will, Mr. Wilson, tax roll 16683, we will label your complaint package called C1, and we will have the clerk number them for us. Yeah, 2 pages. Oh. Okay, there.
For tax roll 16683 for Wilson, we have complainant package labeled C1, which is the complaint form of 2 pages. For respondent package R1, we have respondent disclosure of 49 pages.
Thank you. Mr. Wilson, you can present your evidence, please.
Of course. Yeah, my evidence is limited and constrained by the fact I didn't realize that I was supposed to submit case law. And let's just say when I was at the front desk asking, perhaps the answers were disingenuous. Anyway, suffice to say that I should have done more due diligence, but my main complaint is fairly straightforward and based on essentially 2 things. There haven't been any transactions nor are there any listings in the neighborhood at or above the valuation, ever in history, by the way, at or above the valuation I'm being assessed with. Secondly, there was a recent sale, which I have now discovered because that sale actually didn't close. The sale hadn't gone through, of an almost identical but slightly larger property, 400 square feet of living space larger and a marginally larger lot, 5 doors up the road, that went for 2.2 million. They're assessing me at almost 2.6, 2.588. And even today, if you go look, you won't find anything. And that property was on the market multiple times since 2023, because I know the owners. It's better finished than mine, has granite and things. Finally sold in January this year. This is not all, unfortunately, my disclosure, and this is where they're going to come at me because I didn't realize the rules of evidence applied. But I do want an answer to why they didn't respond, because I'll be back next year, why they didn't respond to the simple claim that the valuation is above anything seen in the market or indeed any recent transactions. They merely responded on, Delta Hotels versus the City of Edmonton and how there's a July 1st cutoff for property sales and things. So it was a technical argument. And I do believe I am due an answer. I expect to lose her, but I'm due an answer because I'll be back next year, which is, do they have to respond to my actual complaint and say why they believe their valuation is fair? Because that was not done.
Respondent have any questions?
No questions, thank you.
Okay, and does the board have any questions? I see no questions. We shall move on. Thank you for your evidence, Mr. Jensen. We will move on to the respondent's evidence, please.
Sure, thank you. So during my presentation today, I'm going to raise several issues. First being, has the complainant met the onus under Section 460 sub 9 of the Municipal Government Act and demonstrated how the assessment is incorrect? The second issue is, has the complainant met the evidentiary burden of proof under Section 460 sub 9 of the Municipal Government Act to demonstrate how their assessment is incorrect? And the third issue is, should the complaint be dismissed under the authority of Section 467 sub 2 for non-compliance with Section 460 sub 9 of the MGA? So now I'm on page 6 of my disclosure. The complainant had a duty to disclose documentary evidence and any written argument by June 5th, 2025. The notice of hearing, which was sent to them on May 21st, 2025, outlined the disclosure responsibilities. The complainant was required to provide disclosure to the Assessment Review Board and the opposing party, Legacy Municipal Services. The complainant has failed to provide any evidence or argument on or before the required date to either party. Matters relating to assessment complaints regulation is clear that the board must not hear any evidence not disclosed within the legislative timelines. And just to quote that section from MRAC, a local assessment review board panel must not hear any evidence that has not been disclosed in accordance with Section 5. So the onus to prove that an assessment is incorrect is the requirement of the complainant. This principle has been well established by the Court of King's Bench and adopted by assessment review boards. Boards have dismissed complaints where the complainant has failed to disclose documentary evidence. And I'm skipping over the board decisions that I have referenced in my material just for ease of the board and the complainant. So now I'm on page 9. And again, there are decisions there, which I'm not going to read, but just to state that in addition to bearing the onus to prove that an assessment is incorrect, the complainant also bears the burden of proof to demonstrate that the requested value is correct. Now I'm on page 10. So the complainant has a multi-step requirement to demonstrate to the board that a change in the assessment is necessary. First, the complainant must show that the assessment is incorrect, and second, convincingly prove that the requested value is correct. In the absence of both, boards have decided that a change to the assessment is unwarranted. And I just want to bring up, on page 11, I mentioned a little bit about post facto sales. So often a complainant will introduce evidence of a market sale or transaction that occurs after the July 1st valuation date in support of its request for a change to the assessment. It's important to note that the use of a post facto sale, which is a sale that occurs after July 1st of the assessment year, is restricted. The board can consider such a post facto evidence to confirm market trends. However, post facto evidence cannot be used in setting value. And again, I've provided decisions in that. And that's in reference to the one sale that the property owner had put on their complaint form. So just in summary, the complainant had a duty to disclose documentary evidence and any written argument by June 5th, 2025. The notice of hearing, which was sent on May 21st, 2025, outlined the disclosure responsibilities for the complainant and the respondent. The complainant was required to provide disclosure to the Assessment Review Board and the opposing party, Legacy Municipal Services. The complainant failed to provide any evidence or argument on or before the required date to either party. As demonstrated, the onus to prove that an assessment is incorrect is the requirement of the complainant. As the complainant has failed to meet this onus, we respectfully request that the Assessment Review Board dismiss this complaint. Thank you.
Thank you. Is there any questions from the complainant? That would be,
Of proof. The challenge, and I talked to Brad Hawker, who you would know, Karen, I ski with Brad periodically, is that unless you're a realtor, you cannot get documentary data on the selling price of a property that is not yours. You have to be registered with the real estate board to have that information. So all I can get as the burden of proof for when I come back next year is, talking to neighbours and getting them to sign affidavits or something. So I need to understand what is acceptable as a burden of proof, because I'm being told I need documentary proof and that recent selling prices are not relevant, which is fascinating in of itself. But short of hiring lawyers, which will cost me more than my property taxes, I would like to understand, because everything she cites is commercial, which is very different. When I'm building a large hotel, I can afford quite a lot of professional services costs. I was more interested in fairness, to be honest with you. But what is the burden of proof that I'm required, and what will it take for you to actually respond to the fact that I'm saying that property prices are X, to which you haven't responded? You've merely come back with a technicality of an act of legislation that I haven't read and case precedent to tell me that you're going to ignore my point, right? That it is not admissible. So what is it that I do require? Because I will be back in a year. Because as you can tell, and I don't want to become emotional, this is, all I was looking for here was fairness, not a process. And it seems stacked against the individual who cannot get access to actual selling prices unless you're a licensed realtor, and basically does not pay professional advisors like yourself to go through legislation and case history. You cited 31 cases, none of them in Canmore. 29 of the 31 were clearly commercial. The other 2, it was debatable because you couldn't tell from the name that they weren't necessarily companies. So what is it you require when I come back next year?
thank you. I was just going to ask you to restate your question.
So through Alberta legislation, there's a complaint deadline. Prior to that, there's 67 days for property owners to contact the assessor to find out information regarding their property assessment. This particular property owner did not contact the assessor during this assessment year to answer any questions regarding their property assessment. There's also been no issues brought forward by the property owner regarding the property data on their property. In regards to the case law, regardless of whether it's a residential property or it's a non-residential property, this case law is still binding for all properties. As mentioned, regardless of whether it's non-residential or residential, the case law is binding, as well as the legislation. So when we're preparing assessments, we're required to prepare them as of July 1st, 2024, and we're required to prepare them as of the market value. This issue had not been brought forward by the complainant in their evidence submitted. They had brought up one sale, which was well after the valuation date of July 1st, 2024, and there's been no other evidence provided by the complainant to demonstrate that their assessment is incorrect. If they wanted additional information to support their assessment, as mentioned, this would have been something that they could have brought forward through the assessment inquiry period from February 13th, which is when the assessment notices were mailed, up until April 22nd, which was the complaint deadline. They also could have, if they had issues with their assessment, brought forward any specific properties, which at that point the assessor would have discussed with them. Thank you.
Because I don't have them.
I'm sorry, what did you say?
I'd like the contact details for the assessor, because I'm going to go contact them now, because I don't have them. So I've been failing in contacting somebody, I don't know who it is.
I believe they're on your tax bill on the back page, or one of the pages.
They're on the assessment notice.
Yeah, I will, yeah, okay.
Okay.
Further, thank you, Ms. Bannerman, for your answering the question. Do we have any questions from the board for the respondent? I see no questions for you. So we are moving on to, do you have any rebuttal evidence you would like, if any?
I only had one question.
sorry.
Is that lady a lawyer? Because she's citing the law and her interpretation of it. I just wondered if she was professionally qualified to interpret the law.
Oh, respondent disclosure? No rebuttal, okay, that's right, okay. My apologies. Okay. So we're going to be moving on to closing comments. Do you have any closing comments, Mr. Wilson?
Only simply, and I think you're sympathetic here, is I find the process quite bizarre that I'm essentially using, or you're using my property taxes to set up a process that is perhaps valid in a commercial situation, seems rather heavy-handed. And I suspect you'll have another one in about 10 minutes in a residential situation, where I'm merely, I paid property taxes in Canmore for 30 years. I'm merely trying to get some level of fairness. And unfortunately, unlike BC, we do not have access to selling price. In BC, you can see every recent sales transaction. You cannot in Alberta, unless you're a realtor checked, when you know Brad.
Okay, thank you.
So no further questions.
Is there any closing comments for the respondent?
Sure. As mentioned, in response to the previous question, case law is binding not only for non-residential properties, but it is binding as well for residential properties. So the complainant did have a duty to disclose the documentary evidence and any written argument by June 5th, 2025. The notice of hearing, which was sent on May 21st, 2025, outlined this disclosure responsibilities. The complainant was required to provide disclosure to the Assessment Review Board and to Legacy Municipal Services. In the absence of any evidence or argument that was provided to either party before the required date, the onus to prove that an assessment is incorrect is the requirement of the complainant. The requirement of the respondent is to respond to issues brought up by the complainant. As the complainant has failed to meet this onus, we respectfully request that the Assessment Review Board dismiss this complaint.
Thank you. And Mr. Wilson, you have last word.
I paid my $50 as a learning experience. I knew what the outcome was going to be. So,
Thank you. So I will now ask the parties if you feel you've had a fair hearing.
the hearing has been fair. The process is rather more complex than I'd anticipated.
Okay, thank you. And the respondent, do you feel you have had a fair hearing?
I do, thank you.
Thank you. I will now declare the hearing closed. And no further submissions or evidence may be received by the board. If the board deems it requires additional information or evidence, a date will be established for the board to receive this information or evidence, and the parties will be notified. I'm on the wrong page then, I'm sorry. Oh, yeah, there. My apologies. It's my first time in a few years being the chair.
It's fine.
The Municipal Government Act requires a written decision within 30 days of the hearing, and it gives the clerk an additional 7 days to issue the decision. We will make every effort to meet or beat those requirements, and the clerk will forward our decision to you at the earliest opportunity. I now do adjournment.
Thank you very much.
Thank you. Yes, I'm going to do that. Oops. The board will now take a 10-minute break, and then we'll hear our next hearing. Thank you. Good morning, and welcome to this Canmore Local Assessment Review Board hearing. I would like to remind everyone that the ARB hearings are open to the public and that this hearing will be recorded and streamed live. The video recording will be our record of hearing. We are here today to review the complaint and subsequent evidence as filed for tax roll 13943. Municipal address is 726 First Street. I will start by introducing the panel. I am the presiding officer. My name is Karen Mara. To my left is Jen Moran, board member, and to my right is Christophe Breyer, who is also a board member. My name, I did that already. Does anyone have any objection to the panel as constituted? No?
No objection, thank you.
Thank you. I am now going to have the parties introduce themselves, starting with the complainant or their representative. Would you please step to the mic and state your name for the record?
Dale McClellan.
And you are the property owner under complaint.
Yes.
Thank you. And to the respondent.
My name is Deanne Bannerman. I'm with Legacy Municipal Services, and I'm the appointed assessor for the town of Canmore.
Thank you. The LRB's standard practice is to have the complainant present all their evidence first, followed by questions from the respondent and then the panel. Next, the respondent presents their evidence, followed by, once again, questions from the complainant and the panel. The complainant will have an opportunity for rebuttal. Finally, both parties will have an opportunity to present their final argument and summarize their evidence for the panel, with the complaint presenting first, complainant. If anyone needs a break or if there is a problem comes up, please let the panel know as soon as possible and we can address those things as we go. I will also take this time to remind everyone to please turn off their mobile devices. Are there any questions regarding the hearing today, the process laid out?
Is this the preliminary thing?
Not yet. It is almost with those there. I see both parties have exchanged disclosure evidence before the hearing. To save time, I propose that we mark all documents for the record now. That way it won't stop anyone raising questions about the admissibility later. If any questions arise, we can still deal with them and strike material from the record later if necessary. Is everyone comfortable with the procedure? Respondent?
Yes, I'm comfortable. I do have a couple of preliminary issues to raise with this case, though.
This is the question now. Are there any preliminary issues for the panel to address? Oh, and yes, the evidence. I'm sorry. So we will have the clerk read into the numbering of the
For tax roll 13943 for McClellan, we have complainant package labeled C1, which is a complaint form, which is 1 page. Complainant package C2, which is a complainant rebuttal, which is 2 pages. Respondent package labeled R1, the respondent disclosure is 43 pages. And we have a package of R2 from the respondent, which is the respondent rebuttal of 9 pages, which I will now distribute.
Okay. I think, there you go. And, yeah, okay. As there is new evidence and it has been marked into the evidence, this board would like to take a 10-minute break to review the evidence that is before us. So we will now take a break.
What's this?
This is a rebuttal from the respondent. It is
Well, wasn't
information.
it due 3 days beforehand?
No, it can be added to the evidence now.
Okay, because I have some evidence too, so.
Oops. There we go.
Sorry, the evidence that was just provided is a rebuttal. So in the, as part of the complaint process, the complainant is required to submit their disclosure evidence. I believe it's 35 days in advance, and then the respondent will submit their disclosure evidence. The complainant then has the opportunity for rebuttal. So those three are marked out in legislation with specific timelines. But because the the complainant rebuttal is due only 3 days before the hearing, the SIR rebuttal is the opportunity for the respondent to respond only to what was in any rebuttal evidence. So that doesn't have a timeline, doesn't need to be presented in advance, but that's just in response to the rebuttal evidence that you had provided.
That's fair.
So we will now take a 10-minute break. You can have a, we will now take a 10-minute break. Yeah, okay, thank you. Okay, we are ready to proceed. Are there any other preliminary issues? I'll have you come to the podium, please.
Pardon me?
Oh, I just asked you to come to the podium, Mr. McClellan.
Are you ready?
Yep.
Yeah. The preliminary issue is here. I never, main issue being, I never agreed to get electronic service for paperwork or whatever you want to call it. And also, I'd like to present a note why I've been off, and I'd missed it, another reason why I'd missed the deadline. I didn't know about it at first, and I don't know, do I give this to Lisa, or?
The clerk can accept the, and mark it in.
Do you need copies? I have some. Do you have for one for each board member? Yeah.
And you have marked that into evidence for numbering. And we're just waiting for Ms. Bannerman to receive the document also. Process. I'm just going to confirm that Ms. Bannerman has received the document.
Nope, I haven't received it yet. Is it being emailed to me?
Oh, yes, it is.
Sure,
I'll be with you shortly.
sure. I've received the document, thank you.
Thank you. Okay, we shall proceed with our preliminary issues. Ms. Bannerman is first, please.
Sure, thank you. I'll just go into my SIR rebuttal first.
I'm sorry.
Oh, can I go into my
Preliminary
SIR
issues.
rebuttal first?
That's what we're doing first?
Yep. And then I'll go into the preliminary issue that I prepared for the disclosure or my response.
I couldn't hear you either, sorry. Could you repeat yourself, please, Ms. Bannerman?
Sure. So I was going to go into the information that I provided in the SIR rebuttal first.
As a preliminary matter?
Yes.
Yes. Okay, proceed.
Okay. Just so that everybody knows where I am.
Yes.
And I apologize that the SIR rebuttal was presented in person this morning, or it was presented this morning rather than in advance, so that the board and the complainant had a chance to review it prior to the hearing. However, the complainant requested that there would be no electronic submissions provided by the complainant or by the respondent. So we didn't have a chance to mail it earlier in our time frame, since we only received the rebuttal from the complainant on June 23rd. So I just want to go into a little bit of information regarding SIR rebuttal and the allowability of it in case law. So in some situations, the evidence that has been adduced as rebuttal by the complainant, which was either oral or documentary, may introduce new information, issues, or evidence which the respondent is entitled to meet by calling SIR rebuttal evidence. And then matters relating to assessment complaints regulation does not require the respondent to disclose its intended SIR rebuttal evidence prior to the hearing, which is why it has been brought forward at the start of this hearing. So with regards to rebuttal evidence, it's only permitted where the information meets two criteria set out in case law. To be admissible as rebuttal evidence, such information must be necessary to answer a matter raised first by the respondent, and it must be information which the complainant could not reasonably have anticipated when the complainant first presented its case. If the information does not meet both of these criteria, it is not properly admitted as rebuttal evidence. So the complainant cannot wait until it receives the respondent's reply and then present additional evidence to bolster its case, raise additional issues, or provide the rest of its evidence. It's contrary to the rules of natural justice to allow the complainant to split its case, which is what it's called, and thereby deprive the respondent of an opportunity to answer all of the complainant's evidence in a thorough and meaningful fashion, if at all. So I've included several decisions in the SIR rebuttal information that I've presented to or provided to the board and to the complainant. So in many situations, this evidence that's been called rebuttal by the complainant is not in fact actual rebuttal evidence. It's new evidence that should have been properly included in the complainant's original submission. If it had been in the complainant's original submission, then the respondent would have had the opportunity to respond to it. So the board is subject to the rules of natural justice, and it's not just to permit the complainant to present new evidence in the form of rebuttal to bolster its case after the respondent has answered the evidence. And again, I've included several court cases that summarizes what rebuttal evidence is. So any information or any evidence that's been submitted by this complainant as rebuttal is not in fact actual rebuttal evidence. It should not be accepted by the board, and it should not be spoken to by the complainant and should be disregarded in its entirety since it wasn't provided in the original disclosure. So now I'm going to go into my response, which would have been R1 in your documents. So, and if we could, for our responses or for my response in both this case and in the complainant's next case, which is this case, which is 13943 tax roll. And the other case, which is being brought forward, is 13944. The issues are going to be the same for both of these properties. And if the board would like, I can bring, rather than presenting my material anew, I can ask the board to bring forward my evidence that I'm providing for both cases.
Yes, that's fine.
Thank you. So on page 3 of my response, there's 3 issues that we're going to bring forward, and this is for both cases. The first one is, has the complainant met the onus under section 460 sub 9 of the Municipal Government Act and demonstrated how their assessment was incorrect? Has the complainant met the evidentiary burden of proof under section 460 sub 9 of the Municipal Government Act and demonstrated how their assessment is incorrect? And I will apologize, there's typos in this case on the second point on that page 3 for this case and the second case. So the assessment that we are talking about for this property is $1,580,000. For the next case, it's $1,746,000. And then the third point is, should the complaint be dismissed under the authority of section 467 sub 2 for non-compliance with section 460 sub 9 of the Municipal Government Act? So now I'm on page 5, and I'm just going to, address maybe the information that the property owner provided, as well as go into the requirements for the complainant to provide documentary evidence. So the complainant had a duty to disclose documentary evidence and any written argument by June 5th, 2025. The doctor's note that was provided says that Mr. McLennan has been off or will be off for medical reasons between March 17th, 2025 and April 11th, 2025. This is the complainant's requirement to disclose the documentary evidence was past this date. It was June 5th, 2025. The notice of hearing was sent to both the property owner and to the respondent on May 21st, 2025, and it outlined the disclosure responsibilities. The complainant was required to provide disclosure to the Assessment Review Board and to Legacy Municipal Services. The complainant failed to provide any evidence or argument before the required date to either party. The Alberta Court of King's Bench, trying to get the verbiage now that we have a king rather than a queen, and the assessment review boards have held that late evidence is inadmissible. The Municipal Government Act and the regulations are intended to standardize the roles, rights, and responsibilities. The onus to prove that an assessment is incorrect is the requirement of the complainant. This principle has been well established by the Court of King's Bench and adopted by assessment review boards. So now I'm on the bottom of page 7 of my response, and the boards have dismissed complaints where the complainant has failed to disclose documentary evidence. I'm on page 8. I've included all the decisions, but I won't read them all for you. In addition to bearing the onus to prove that an assessment is incorrect, the complainant also bears the burden of proof to demonstrate that the requested value is correct. Further decisions are there. Now on page 9, the complainant has a multi-step requirement to demonstrate to the board that a change in the assessment is necessary. First, the complainant must show that the assessment is incorrect. And second, convincingly prove that the requested assessed value is correct. In the absence of both, boards have decided that a change to the assessment is unwarranted. So in summary, the complainant had a duty to disclose the documentary evidence and any written argument by June 5th, 2025. The notice of hearing, which was sent by the Assessment Review Board clerk on May 21st, 2025, it outlined the disclosure responsibilities. The complainant was required to provide disclosure to the Assessment Review Board and to the opposing party, Legacy Municipal Services. The complainant failed to provide any evidence or argument on or before the required date to either party. As demonstrated, the onus to prove that an assessment is incorrect is the requirement of the complainant. As the complainant failed to meet this onus, we respectfully request that the Assessment Review Board dismiss this complaint. In addition, with my SIR rebuttal, we're also asking that the information that had been provided as new evidence that hadn't been disclosed within the proper timelines also be omitted, which is why we're asking the board, with the absence of any evidence from the property owner, to dismiss this complaint. Thank you.
Thank you, Ms. Bannerman. We now will hear preliminary issue from the complainant. Is that correct? Preliminary issue only. So that would be the. Preliminary, okay.
I'm confused here because in her SIR rebuttal, or whatever you want to call it, she was saying, oh, you know, there's not time to mail it out because I agreed to mail service, okay? So obviously it's not going to get their rebuttal in 3 days. Yet on this thing there, she says May 21st, it was emailed to me. So, you know, and then I have a letter here dated June 13th, where they mailed it to me. So I never agreed to email service. And there's some serious confusion here. She said, well, that's the way you want it. So then, you know, what's going on? Anyways, I guess we can move forward. But I'd respectfully ask that because of the doctor's note, and I'm not going to get into my health,
No.
but I can get another note, more notes. I'm still getting treatment. I'm off. And my rebuttal letter was written by someone else. I was going to hire someone to do it. So respectfully ask that I would, you know, get a continuance or an adjournment so I can get my disclosure in, because there is a lot of stuff, and I don't know what else to say.
I have a question.
Sure.
I've never seen one of these. When did you receive this?
That? Well, I got the original, but I got that emailed to me either yesterday or the day before.
So it says signed June the 25th? So yes, 2 days ago?
Yes.
Uh-huh.
No, the nurse assistant emailed it to me because I couldn't find the original.
And then it's dated in March.
Yes.
Okay, so it's dated in March and you received it
I
3
received a
months
copy
later?
of it because I didn't have the original. I'd recycled it.
That's what I'm asking. Okay,
Yeah,
so,
the
so,
the
so you
doctor's
received
office.
it in March and you didn't have it, and then you asked for a new copy as of
Correct.
yesterday?
Yes, sir.
Okay, now I got it. That was my question. Thanks.
So we will take, that's all of your information, your preliminary issue? That's your
Yes.
preliminary issue? So we will take a 10-minute break, correct? To review? Okay. We will take
Okay,
at
thank
least
you.
a minimum of 10-minute break.
Yeah, thank you.
To review the preliminary issues. I don't know if Ms. Bannerman is back. Thank you, Ms. Bannerman. I will proceed with this hearing. We have heard the preliminary issues, and they were, three preliminary issues were non-consent to electronic communication, a doctor's note, and from the respondent was no evidence, and the respondent's rebuttal. With the board reviewing and deciding on the preliminary issues, we have decided to dismiss the case for these issues, and I thank you for your cooperation and your presentations. So I will. Oh. Yeah, I said that, yeah. Oh, address why? Okay, I apologize. So the doctor's note we found was the dates, and it could have been presented earlier. And we did see that there was electronic communication and printed communication given to the complainant. And we do feel that the respondent has provided that there was no evidence in their rebuttal. So that for those reasons, we are dismissing the case. So I will now declare the hearing closed. And so the Municipal Government Act requires a written decision within 30 days, and it gives the clerk an additional 7 days to issue the decision. We will make every effort to meet or beat those requirements, and the clerk will forward our decision to you at the earliest opportunity. We may now proceed to our next scheduled hearing, which is Mr. McClellan again. So for procedure, we will welcome everyone to the Canmore Local Assessment Review Board hearing. I would like to remind everyone that the ARB hearings are open to the public and that this hearing will be recorded and streamed live. The video recording will be our record of hearing. We are here today to review the complaint and subsequent evidence as filed for tax roll 13944. Is that correct? Yeah, 44. And the civic address or municipal address is 722 First Street, Canmore, Alberta. I will reintroduce the panel. Myself as presiding officer, Karen Mara. To my left is our board member, Jen Moran, and our board member, Christopher Baer, to my right. Does anyone have objection to this panel? No. No. I see none. Because we're going to hear from parties. We're not going to hear from parties because we're carrying evidence forward. It's the same party and disclosure, just the tax roll and civic address is different. So we will be carrying the evidence forward from the preliminary hearings, or preliminary issues, apologies. So it'll be the same preliminary issues, and for that reason, we will dismiss the case also. I will now declare this hearing closed, and the same will take effect for the Municipal Government Act will give you a written decision within 30 days and gives the clerk an additional 7 days to issue a decision, and we will make every effort to meet or beat those requirements, and the clerk will forward our decision to you at our earliest opportunity. Thank you. They were dismissed due to, and there will be a decision written to you for both properties separately, the decision that the board has made. So it was the preliminary issues that was the decision. The preliminary issues? And there was evidence, so there was a request for dismissal, and there was, I can't discuss that case. Oh, you can hear comment from our minutes, our clerk. You can hear comment from our
Sorry,
clerk.
just as the clerk, just to explain the procedural part, I'm not part of any decisions. Well, the reason that this one was just opened and closed is because there was a request made in the last hearing to carry forward the evidence that the two properties were so similar, the issues were similar. So the preliminary matters from your last hearing, which were the non-consent to electronic notification, the doctor's note, and the request from the respondent to dismiss the hearing based on no evidence. Those preliminary matters were decided in the last hearing and were carried forward to this hearing. So it's just a procedural thing that this hearing was. Well, the rebuttal becomes moot because the hearing was dismissed. It's only.
Thank you.